Okay. So, my name is Emily Schwab of law firm Hazel and Schwab, and I'm here to talk to you a little bit today about custody. And again, this is just going to be an overall general idea. And remember that every case is different, and I can't give you legal advice through the internet. But let's get started. So, the first thing you have to remember with any custody is that this is about your kids. And so we need to keep them as out of this court process as much as possible. You know, it's going to be difficult, but try not to say anything mean or nasty about the other parent to or around the kids. Adult relationships end, and that is what it is. But we need to make sure that your kiddos know that they have somebody who really loves them and who cares about them. So there's 3 steps to every family law case. So it's temporary orders, mediation, and then trial. So before you can even file a case, you need to see whether or not the father is on the birth certificate. If he's on the birth certificate, then you go in, you file your petition for residential schedule / parenting plan, and then you'll move on from there. If dad is not on the birth certificate, not a big deal, just requires another step. So you'll file for a determination of parentage. And so either dad has to sign an affidavit saying, yes, I promise I'm the dad, or we can do a DNA test. And so after that point, we all get back on the same track. So that temporary order hearing is just what it sounds like. It's for orders that are temporary. And so that's the point where you're going to ask the court to do what you want it to do. So when making a determination about initial custody, the court wants to know who has been the primary parent and what is going to be least disruptive to the kids. And that seems like kind of a big question, who's been the primary parent. But the court's going to want to know things like who takes the kids home and drops them off at daycare, who helps with homework, who makes breakfast every day, which parent does the child go to when they are sad, who's the one that stays up late writing bedtime stories. And that's the thing that the court wants to know. And if you've already separated and you're doing some kind of custody arrangement, the court should know that too. Because if there's something that's working between you, works for your kids, then the court's going to want to keep things as stable as possible. And so at the very beginning, like I said, you're going to draft up a parenting plan, a proposed parenting plan. And that's when you go through and say, here's the schedule I think we should have. It includes holidays, pickups and drop-offs, and the whole 9 yards. And so you're going to file that with the court to give them a general idea of what you're asking for. And at the same time, you're going to write a declaration or a sworn statement in support of your proposal. And it's really, really important to know that when you go up to argue your case, if it's not in the file, you haven't filed the declaration, then the judge can't consider it. And so this declaration is one of the very most important documents in your whole case. And we're not interested in, I'm the best dad ever and mom is the worst. Well, tell us why. And so that's where you're going to go through and list all those things we talked about. Here's what I do as a parent. Here is why you should do what I want you to do. That's also the time to bring up concerns you have with the other parent. If there's a history of substance abuse, domestic violence, any kind of verbal, emotional, physical abuse of any kind, if the other parent doesn't really have a great relationship with the child, that's something else the court needs to know. And again, a key issue is court cannot get any statements from children. And it comes back to that cardinal rule of keeping them as out of this as possible. So in addition to your statement, you can file similar statements from friends or family or other people who have personally seen what kind of a parent you are. Again, we're not looking at my friend's awesome. Well, great, I'm sure you are. But, I have personally seen this mom take her kid to school every day. I've personally seen this dad tuck his kids into bed. And all that information you're going to file, give it to the judge. And then the opposing party will do the same. And then at that hearing, you or your attorney will argue those facts. And the judge has read absolutely everything. And so if you forget something in argument, don't despair. And at that point, you'll get a temporary parenting schedule and child support. That's something else to remember to always ask for. And when you first file, you'll get a list of the documents the court needs, but it includes pay stubs, taxes, that kind of thing. Because not only is spending time with your kids important, getting the financial support that they need is also really significant and really important. And so once the judge makes that temporary decision, it will be in place until there's an agreement of some kind or a further court order. And so that's the first step. We're done with that. So then the second step is mediation. So Yakima County has a requirement that we try to mediate all family law cases before we can get a trial date. And what that looks like is it's a big negotiation. So we all sit down and see what can we work out and what can we live with. That's going to be the best interest of parents and of the kids. Oftentimes, people who don't have attorneys go to the Dispute Resolution Center of Yakima and Kittitas counties. They're really good at what they do and trying to get everybody to have a conversation and have it work. There's also private mediators that a lot of attorneys use. It's just a similar procedure, but a little bit of a different outlook and perspective. And so, nothing bad can happen to you in a mediation. Best case scenario, you have an agreement and you're ready to draft up final papers, and that's great. We always prefer when people can work together for the best of their kids. Worst case scenario, you don't get an agreement, you get a trial date. And at that point, it'll be the whole enchilada. Judge, witnesses, exhibits, just like you would see it on TV, but rarely as dramatic as Law and Order would like you to believe. And then, as a pending an agreement or a trial, at that point, your case is over. And you'll draft up final documents accordingly. And it's really important to know that once a parenting plan is finalized, it's really difficult to change it. And so before you agree to something, make sure that it's something that you are going to be able to follow through with and that you really do think is going to be best for everybody. I have a couple of questions that have come in and a couple of questions that I get pretty often and regularly from my clients. And one of the most common one is, at what point do kids in Washington State get to decide where they live? And the answer is 18. There's actually direction from the Washington State Supreme Courts that the residential parent is required to make that child go visit the other parent if he or she doesn't want to. And I know that that's hard, and that's something that on a case-by-case basis you'll have to figure out. But that's the direction. And similarly, a lot of people want to know how child support plays into residential time. So if a parent is behind on their child support, it doesn't mean the visits stop. The visits continue, and the child support obligation should continue, but they're not necessarily related in that way. However, the importance of having a child support order means that you can go into court and get it enforced. I have a lot of opinions about a lot of things, but people who don't pay their child support is something that we really struggle with as attorneys and in the court system. So stay on top of your child support. A couple other questions that came in directly to the VAS today is, what are we doing about COVID? And that is the question we're all asking ourselves in every aspect of our lives. But as far as parenting schedules, the directions that we've received from our courts, from the state courts, is that you're going to try as best as you can to follow your existing parenting schedule. And actually, courts have found people in contempt or in violation of parenting plans when they have refused the regular residential schedule and visitation during COVID. And that's the part where you're going to have to find some measure of trust with the other parent. And whether they're making the best decisions as far as social distancing, there's only so much that we can do about it. But that's where trying to keep some kind of open communication between the parents is really, really important. That's a conversation you can try to have, but at some point you're just going to have to do your best efforts. And if someone comes down with the virus, then you can work together to move some times around, make sure that their FaceTime can be used. There's a bunch of different ways we can do it. But unless you have something that's significantly putting that child in danger, you've got to stick with the best that you can do. There was also a question about travel with parenting plans. And here's my typical attorney disclaimer. I haven't seen your actual parenting plan, and so I can't tell you precisely what to do. But this is something that comes up, not infrequently. So some parenting plans will have a provision in them that says, you must get permission from the other parent to take the child out of state, out of county, out of the country. And so if that's the case, then you need to give formal notice to the other parent. And if that's not specifically in your parenting plan, I think it's just good form and helpful to give them a heads up. Hey, we're going to California. Wanted to let you know. If it impacts the other parent's residential time in any way, then you'll need to work up some kind of an arrangement for makeup time or something to that effect. And traveling internationally, I believe that the Department of State requires both parents to sign off on applications for passports and other international travel. You'll have to talk to them because they know more about it than I do. But if the other parent refuses to cooperate, then you can bring a motion before the court to compel them to sign the necessary documents so that you can take your child on your scheduled trip. And so I've done a couple of those, and the courts are pretty willing to work with people on that. There's also a question about third-party cases, and this is a whole area of law that is continuing to update and to change. I am not an adoption attorney. I can't give you any legal advice about that, but I can tell you that if mom and dad aren't fit and a third party, so a grandma, grandpa, aunt, friend, whatever, would like to get custody of that child, then they can go through the third party system. And that's saying, I'm not a bio parent, but it's the best interest of this kid for them to live with me. And that it's a little bit harder than it used to be in order to get that final custody determination. But at some point, if you believe that adoption is the best way to go about it, then I encourage you to get in touch with somebody who can better help you with that. Let me see if I have any other. Okay. And then just like that, the summation of all this is that parenting plan is the very basics. So it's the default. If parents can't get along, or if we're not really sure, then pull that parenting plan out. Make sure you have a copy of the most recent parenting plan. But if the two of you can work together and change things, switch days back and forth, I know people who have their parenting plan in a drawer and they never take it out because they can just co-parent. Well, and obviously that's the goal for everybody, to try to get along with the other parent for the sake of their child. But having a parenting plan is really important, so you do have that fallback if necessary. And if someone's not obeying the parenting plan, you have the ability to take it to court and say, I didn't get my visit time, or mom didn't bring the child to my visit on time, and have that enforced. And so that's, like I said, 101. Obviously everything's different. There's all kinds of different things that can show up. But at the end of the day, it's about making sure your kids have what they need, and that mom, dad, and other people who love them are going to continue to be there for them. So good luck, and we'll maybe see you again, maybe not. Thanks.